Good morning, everyone. I'm Shivani Nair, and today we're going to talk about first appeals. So, what are first appeals? Let me just share my screen. Before we start with first appeal, I want you to know what exactly appeal is. An appeal is the complaint to a superior court of an injustice done on an error committed by an inferior court, whose judgment or decision the court above is called upon to correct or reverse. The removal of a cause from the court of an inferior to one of a superior jurisdiction and for the purpose of maintaining a review or a trial. So that appeal is done so as to remove the corrections or the errors, to make corrections or to remove the errors done by the lower court by a superior court for the purpose of obtaining a review or a retrial. Now, Section 2, Clause 9 of the Code of Civil Procedure states that a judgment, it talks about the definition of a judgment, which states the statement given by a judge on the grounds of decree or an order. Now, what is decree? Section 2, Clause 2 provides that a decree is a formal expression of an adjudication which conclusively recognizes the rights of the parties with any of the disputed matter in a suit and may be preliminary or final. What are the essentials? The decree passed by a judicial administrative authority. Essentials of an appeal. Now, first is the decree passed by a judicial administrative or an authority. Second is the aggrieved person, not necessarily a party to the original proceeding. And then thirdly, a person reviewing body instituted for the purpose of entertaining such appeals. Right to appeal. Now, who has the right to appeal? The right to appeal is a statutory right and a substantive right. Therefore, one right to appeal is by a party who is aggrieved by any decision of an inferior court has at least one right to appeal to a higher authority under section 96 of the Code of Civil Procedure. Then who has no right to appeal? No right to appeal. A person has no right to appeal against a decision unless he is a party to the suit, except on special leave of the court. Where there is a special leave petition, in that case, unless he is a party to the suit, in that in that specific case, only person will not. Apart from that specific case, no person shall be allowed to be given the right to appeal. Forms of appeal. In how many kinds the appeals can be divided? Appeals may be divided mainly into two kinds. First one is first appeal, and second one is second appeal. Subcategories under appeal are appeal from original decree, appeal from the order, appeal from appellate decree, or appeal to the Supreme Court. Now we start with first appeal. Section 96 of CPC provides that appeal shall lie from a decree passed by any court exercising such original jurisdiction to the authorized appellate courts, except where they expressly prohibited. A combined reading of Section 2 Clause 2, which is the definition of a decree, Section 2 Clause 9, which is the definition of a judgment, and Section 96, which provides for appeal of CPC, indicates that a regular first appeal may or may not be maintainable against certain adjudications. Now, who can appeal and who cannot appeal? Any person who is affected by the decision of a lower court can appeal to the higher appellate authority on a substantial question of law. Appeals are always made on a substantial question of law. Where there is no substantial question of law, you cannot point out or you cannot go for an appeal. A party who waives his or her right to prefer an appeal against a judgment cannot file it at a later stage. Once you have waived your right to appeal, you cannot file it at a later stage. If a party ratifies the decision and accepts the benefits provided under it, it may be estopped from appealing that judgment in a higher forum. The rule of estoppel applies where a party has ratified the decision and accepted the benefits which have been provided by the forum. The rule in the case where appeal is preferred not against the opposite party but against the co-defendant or co-plaintiff on the question of law, it could also be allowed. Where you are not going against the opposite party, being, for example, you are a plaintiff and going against a defendant, even in such a case where you do not go against the defendant in such a case but go against your co-plaintiff, in such a cases as well, appeals may be allowed. Appeal against ex parte decree. In the first appeal under Section 96 Clause 2, the defendant on the merits of the suit can contend that the materials brought on record by the plaintiff were insufficient for passing a decree in his favor or that suit was not otherwise maintainable. He or she may make such an application to set aside such an order. This is the appeal against the ex parte decree under Section 96 Clause 2 of the Code of Civil Procedure. Then, no appeal lies against the consent decree or against a petty case. Where there is a consent decree made or where there is a petty case in the order, the case is trivial. In such a case, no appeal shall be made against them. Now, Section 96 Clause 3 states that based on the principle of estoppel, it declares that no decree shall be passed by the consent of no decree passed by the consent of both the parties shall be appealable. Where there is a decree in a consent form, there no appeal lies against that decree where the decree was based on a consent form of both the parties. Section 96 Clause 4, it states the appeals except on points of law in cases where the value of the subject matter of the original suit does not exceed 10,000 rupees as recognized by the Judicial Code, Subordinate Code. So, Section 94 Clause 2 puts a bar upon the petty cases where the matters are again in petty cases where the matters are up to 10,000 rupees against those below 10,000 rupees or up to 10,000 rupees, no matter shall be appealable. Appeals against a preliminary decree. Section 97, it provides that failure to appeal against a preliminary decree is a bar to raising any objection to it in the appeal against a final decree. It provides a bar against raising an objection to it before the final decree is passed. The object of the section is that questions which have been urged by the parties and decided by the court at the stage of preliminary decree will not be open for a re-agitation at the stage of preparation of the final decree. Therefore, it would be considered finally decided if no appeal is preferred against it. Now, powers of an appellate court. What are the powers of an appellate court? Section 107 prescribes the powers of an appellate court. First one, to remand a case. Second one, to frame issues and refer them for a trial. Third one, reappraisal of evidence when finding a fact is challenged before it. Fourth one, to summon a witness. Fifth one, to reverse the inference or the findings of a lower court if it is not found justified by the higher court. And sixth one is appreciation of evidence. What are the duties of an appellate court? The appellate court has the duty to analyze the factual position in the background of the principles of law and then decide the appeal. Factual positions are to be analyzed in the background of principles of law, which is on basis of the substantial question of law brought before it. Then, to provide cogent reasons for setting aside a judgment of an inferior court. To delve into the limitation under Section 3 Clause 1 of the Limitation Act, to decide the appeal in compliance with the scope and powers conferred to it under Section 96, read with Order 21, Rule 31 of the CPC. Letters patent appeal. Section 100A explicitly bars letters patent appeal from an order of a learned single judge of a high court. After 2002, this was decided in an appeal arising from an original or an appellate decree. So an appeal, letters patent appeal, which arises from an original or appellate decree, in such a case, Section 100 Clause A, Clause A, 100A, Section 100A explicitly bars the letters patent appeal. The bar is absolute and applies to all appellate orders, regardless of whichever order it has arisen from. Now, appeal to Supreme Court. Under Article 133 of the Constitution of India and Section 109 of CPC, it provides certain conditions under which an appeal could be made or filed to the Supreme Court of India. First, from a judgment or decree or a final order of the court. Second, a case pertaining to a substantial question of law of general significance. Third, The High Court opines that it will be fit for the Supreme Court to deal with such a question. If the High Court states that this particular question is fit for the Supreme Court for the Supreme Court for it to decide, then in such a case, the appeal could be lied to the Supreme Court of India. Conclusion. So, appeals are recognized as statutory rights. Summing it up, what are appeals? Appeals are recognized as statutory rights of a person who is aggrieved by any decision of the inferior court in the interest who seeks interest of the justice. First appeal is a form of appeal which is prescribed under the Code of Civil Procedure. The period of limitation in case of an appeal to file the first appellate authority is 90 days, where it lies to the High Court of India. Finally, it can be concluded that the provisions of Code of Civil Procedure extensively deal with substantive as well as the procedural aspects relating to all kinds of appeal, while making modifications in order to be more accommodative and more specific legislations. So summing it up, we can state that the appeals lie from lower court to a higher authority, in such a case the high courts, under which are the important sections that are to be mentioned? Section 96, Section 97, Section 2 Clause 2 and Section 2 Clause 9 are the important sections to be kept in mind while dealing with first appeal. Thank you.